A recent prison sentence for a former Louisville police officer connected to the 2020 death of Breonna Taylor has cast a bright light on a dramatic shift at the United States Department of Justice. What happened in the courtroom and what it signals for police reform is our focus for the next 4 minutes. Former Officer Brett Hankinson has been sentenced to 33 months in federal prison. A jury convicted him in late 2024 of violating Breonna Taylor's civil rights by firing 10 shots blindly through a covered door and window, endangering Taylor and a neighboring family. He is the only officer charged, convicted, and now imprisoned in connection with the raid. Here's where the story takes a sharp turn. The very Justice Department that secured Hankinson's conviction under the previous administration later urged the judge to give him just 1 day behind bars. The recommendation came in a sentencing memo signed by the new head of the Department of Justice's Civil Rights Division, Harmeet Dillon. The memo said Hankinson was not responsible for Taylor's death and argued that a longer sentence would be unjust. Judge Rebecca Grady Jennings forcefully rejected that argument, calling the 1-day proposal inappropriate and incongruous. She said it treated the shooting as merely an inconsequential crime for which nobody needed to be held accountable. In the end, she imposed the 33-month term. To understand why this clash matters, it helps to revisit the tragedy itself. On March 13, 2020, plainclothes officers executed a no-knock warrant at the apartment of Breonna Taylor, a 26-year-old emergency medical technician. They were investigating an ex-boyfriend, but no drugs or money were found. Thinking intruders were breaking in, Taylor's boyfriend fired a legal warning shot. Officers responded with 32 bullets. Taylor's death ignited nationwide protests and became a defining moment for the Black Lives Matter movement. Fast forward to today, and the dispute over Hankinson's punishment fits into a broader federal rollback. In May 2025, the Justice Department began ending court-enforced reform agreements, known as consent decrees, with the Louisville and Minneapolis police departments and halted similar probes elsewhere. Officials said federal micromanagement of local police should be a rare exception, not the norm. Federal grant priorities have also been rewritten. Language about building trust and assisting underserved populations has disappeared, replaced by goals like immigration and border security, violent crime prevention, and uplifting the image of the law enforcement profession. For Breonna Taylor's family, the outcome is bittersweet. Her mother, Tamika Palmer, called the 33-month sentence not justice, but essentially what I started out for, which was jail time. She described the 1-day recommendation as an insult. Family attorney Ben Crump called it a blatant betrayal of the jury's decision. The stark gap between the judge's sentence and the Justice Department's request reveals an intensifying debate over how and whether the federal government should police the police. For communities still demanding accountability, the Hankinson case is a reminder that the future of reform may hinge as much on shifting political winds as on courtroom verdicts.